May it please the court.
Okay.
Recalling case number 32323 of 2022. That's the Minister of Home Affairs, the Director General of the Department of Home Affairs and All Truck Drivers Forum and Allied South Africa versus Helen Suzman Foundation and the Consortium for Refugees and Migrants in South Africa. May it please the court.
Thank you. Ms. Steinberg?
My lady, my lords, this is indeed a matter of great importance and public significance, but that is not enough. The test is the prospect of success. It really begins and ends there, whatever the nature of the matter. In our heads of argument, at page 4, paragraph 12, we set out the test, and there has to be a truly reasonable prospect of success, and that's a quote. Another quote is, a realistic chance of success on appeal, a mere possibility of success, an arguable case, or one that is not hopeless, is not enough. So that is really the simple question before this court. Is there a realistic prospect that another court might come to a different conclusion? Paragraph 22 of our heads, page 7, we then actually quote the SCA, which says that the prospects of success remain, quote, a vitally important consideration in considering compelling reasons. The lack of prospects is often decisive. And really, in short, our argument is that there are actually zero prospects of success in this case. And this is why. Contrary to my learned friend, Mr. Makari's submissions, this issue does not raise a matter of constitutional importance. It's constitutional and admin law 101 with respect. It is the first principle of natural justice, audi altrum partem. It is common cause that this decision impacted on the lives of 178,000 people and their children. And of course, all the South Africans whose lives are inextricably bound up with the 178,000. And in law, there is a watertight obligation to hear what affected people have to say before a decision impacting on their lives is made. It is the first principle of natural justice. It's common cause that the minister did not, in fact, hear from the affected people before making the decision. He called for representations later. Now, it matters not whether Paja is at play or the principle of legality is at play, because both cover the question of audi as a founding principle. Likewise, whether it's Section 3 or Section 4 of Paja, it matters not. People affected by decisions have an ironclad right to be heard before the decision is made. And as Justice Motta pointed out during the case itself, the rationality, procedural rationality, takes us a long way. We don't even have to go a long way. This is audi. And with respect, that is the beginning and the end of this case. There is no court in South Africa that would ever say that the minister is entitled to make a decision which profoundly impacts on the lives of many, many people without hearing from them first. the Constitutional Court recently found in the ETV case that a decision was irrational and procedurally unfair because it affected people's right to watch TV in the ETV case. This affects people's whole lives, where they live, where their children go to school, how they earn a living. There's no question that arises that any court would entertain. And justices, you will be aware more than I that the SCA on repeated occasions has frowned upon high courts granting leave to appeal where there is just no prospect of success. And our submission is that there really can't be. The question as to who made the decision. The DG's memo to the minister gave him options. It can be 12 months, 3 years, you choose. He chose 12 months. He made the decision. As Judge Morter pointed out, there's now a new case on appeal, which is impermissible, that he did in fact make that termination decision. The point is, though, that this court handed down judgment on the basis that he did make a decision. That ground is covered. This court treated the matter that the minister made a termination decision, a final decision, and the court was emphatic on that. Now, again, Admin Law 101, the minister makes the decision. The minister is required to apply his mind. And there is no evidence that he did. The question of the plan made pursuant to the decision and the orderly conduct of how the process of the Zimbabweans returning to Zimbabwe it just doesn't arise, because there's no evidence that the minister applied his mind to the antecedent decision. My lady, my lords, since this court handed down judgment, the Supreme Court of Appeal handed down judgment in the case of Full versus the JSC, which is quoted in our heads. And that case concerned the impeachment of Mutata. And in that case, as the judgment tells us, at the evidence that was adduced on behalf of the JSC was from the secretary of the JSC. He deposed to the affidavit. And no one who sat on the JSC in the disciplinary commission, the disciplinary committee of the commission, made a confirmatory affidavit. It was merely the evidence of the secretary. And he said the facts are within my personal knowledge and are true and correct. And they said, well, at paragraph 27, I'm going to read the paragraph. The SCA held, had the JSC merely participated with a view to placing the record of its deliberations before the court to assist in consideration of the matter, there could hardly have been any objection to Mr. Chilwani deposing to an affidavit for that purpose. Not so once it decided to oppose the application. As a lay witness, it was simply not open to him to depose to all manner of opinion evidence. Now, the parallel in this case is not opinion evidence, but it was a decision to which the minister had to apply his mind. The DG did not have to apply his mind. The minister had to. And the court goes on to say in the same paragraph 27, Mr. Chilwani's affidavit was not accompanied by even a single confirmatory affidavit from any of those persons with personal knowledge of the facts. The High Court approached the evidential material proffered by Mr. Chulwane in his affidavit as if it constituted proof of the truth of the matter so asserted. In that, as counsel for the JSC accepted at the bar in this court, it erred. For my part, I am willing to pass over the issue because, on the view I take of the matter, even on the JSC's own showing, the decision of the majority does not survive scrutiny. In other words, the court is saying, had the decision actually survived scrutiny, we would have we would have found against the JSC on the basis that there was no evidence submitted to this court. But since even if we accept their answering affidavits and their submissions, it doesn't survive scrutiny, we'll look at it. And the court did so because in that matter, it was the first time the SCA had ever dealt with a test for impeachment and felt that it was very important to do so. Now, I submit that this case is on all fours with that JSC case. This court could begin and end the case by saying there is no evidence that the minister applied his mind to this case. If the court chose to, it could go further to say, well, even on the merits, it doesn't survive any scrutiny because the facts, the common cause facts, are that the minister heard from nobody and the department heard from nobody before it made a decision with profound impact on the lives of hundreds of thousands of people. And again, that is the end of the case. And there is no prospect that any other court in the country could possibly find otherwise.
Ms. Steinberg,
Yes, Judge Malindi.
if you could assist me there, did the SCA then proceed on the basis of common cause facts, excluding the affidavit, the evidence in the affidavit, or in consideration of what has been rendered common cause facts, including the affidavit?
The court said at certain points, even if we accept the evidence of the JSC, so it qualified it. It was saying we shouldn't, but even if we accepted it, we still find that the JSC has no case. So it was saying we don't accept it, even if we did, and we only do for the purpose of creating precedent for the lower courts. I mean, that's the implication. The judgment doesn't say that. But it says this matter is an important enough one and it's a novel enough one for us to at least begin to lay out the test for the impeachment of a judge, because it hasn't been before us before. But it's very clear that it did not accept that evidence.
So does it mean that in this case, we could say we grant leave because of the common cause understanding that this matter is of great importance, and maybe the SCA acting as it did in Full versus JSC may take consideration of what may emerge as common cause facts?
Judge Malindi, I think you could, but my submission there is, let's assume the minister had deposed to that affidavit. There are no reasonable prospects of success that any other court could say, absent consultation, the minister was entitled to make this decision. And that is our primary submission, that actually it makes no difference at the end who deposed to the affidavit. There is no case.
Thank you very much. Thank you, my
yes.
sister.
Yes.
Thank you.
Now, on the question of relief, Mr. Macquarie will correct me if I'm wrong, but he seemed to submit that Section 172 of the Constitution and Section 8 of PAJA created different regimes for remedy. And Milady, my lords, that is not the case. And I will read the court one paragraph in the All Pay case, which put this matter to rest. The reference is 2014, Volume 1, SA 604 CC at paragraph 25. And the court said, and I quote, "Once a ground of review under PAJA has been established, there is no room for shying away from it. Section 172(1)(a) of the Constitution requires the decision to be declared invalid. The consequences of the declaration of unlawfulness must then be dealt with in a just and equitable order under Section 172(1)(b). Section 8 of PAJA gives detailed legislative content to the Constitution's just and equitable remedy." With regard to costs, my lady, my lords, Mr. Macquarie relies on BioWatch to argue that the minister should not be burdened with costs. With respect, the principle in BioWatch does not exist to protect the state from costs. It exists to protect litigants who wish to challenge law or conduct. And paragraph 3 of paragraph 23 of BioWatch is very clear in this regard. And paragraph 56, 23, and 56. And they're long paragraphs. I'm simply going to read one sentence. It says, "If there should be a genuine non-frivolous challenge to the constitutionality of a law or state conduct, it is appropriate that the state should bear the costs if the challenge is good." It says, in this way, responsibility for ensuring that the law and state conduct is constitutional is placed at the correct door. So there is no case in which a court has applied the BioWatch principle to government's costs, because there can never be a chilling effect on government in defending its conduct or law, because the state has a budget and needs to have a budget to defend its conduct and its laws. BioWatch exists for litigants, NGOs, etc., to allow them to challenge this conduct and law without fear of being burdened with costs. With regard to Mr. Mojapelo's submissions, nothing Mr. Mojapelo can say can overcome our main submission, and that's that the minister made a decision of great import on people's lives without consulting. And there is, in fact, no third party that can ever be heard to say anything that can change that. So whatever happened or didn't happen to his client does not change the prospects of success on appeal. No full bench or the SCA is going to say it's okay to make a consequential decision without consultation. With regard to the costs order against his client, I merely remind the court why the buyer watch principle is not applicable there. And that's because Judge Davis recorded that he allowed the intervention of that party on a very narrow basis. And that was, merely to provide an affidavit to support the submissions. But what they did in defiance of that order was to launch a whole counter application. And this court correctly dismissed that with costs as vexatious. It was a waste of the court's time. And it was contemptuous of Judge Davis's order. And of course, BioWatch, in fact, explicitly says that where a challenge is frivolous is the word they use. Of course, vexatious or irrelevant in any way, the principle would not apply. And we submit it's as simple as that. And just to remind the court, there was no condemnation application before the court. There was no discretion involved. And unless the court has other questions for me, really those are our submissions. We say we're not going to re-argue our case. We say that there cannot be a more open and shut case. Then Audi's required, common cause, Audi wasn't afforded, end of story. And the details really matter not. Paja, Constitution, which section, it really doesn't matter.
So the case for well, at least the first applicant is that the respondent here rather is that the court should refuse leave to appeal.
With costs.
With costs. Judge Malindi, any questions?
None at all. Thank you, my sister.
Judge Motown?
Yeah, I have a few questions, maybe just one. Having listened to all the parties and also having read the judgment, the inescapable conclusion is that everyone is at ad idem, that this is indeed a matter of great importance and of great public importance. Now, if that is our starting point, then it takes me straight to section 17(1)(a), Roman figure 2. In this respect, I wish to refer you to the case of the Minister of Justice and Constitutional Development, versus Southern African Litigation Center and others. It's a 2016 decision, 3SA 317. Where I want to take you, it's page 329, paragraph H. The court is dealing with the, I think you muted.
Judge, would you give us a moment just to get there so that I can follow with you?
Yes.
One of you pass me a... my Lord, did you say paragraph 23?
It's page 329, paragraph 23. Yes.
I'm with you.
You with me? Yeah, it gives me a sense of ambivalence as to where one should go with this matter. Let's go to, I'm quoting now, under H, but it failed to consider, I quote, it failed to consider the provisions of section 17(1)(a), Roman figure 2 of the Superior Court Act, which provides that a leave to appeal may be granted notwithstanding the court's view of the prospects of success. Let me just pause there. we have our view on the prospects of success, and I think I'm in agreement with you as far as that is concerned. But then if you go further, now it ties in with what I started off with. The usual ground for exercising that discretion in favor of dealing with it and the merits is that the case raises a discrete issue of public importance that will have an effect on future matters. That jurisprudence should have been considered as a guidance or guide to whether, notwithstanding the High Court's view of an appeal's prospects of success, leave to appeal should have been granted. In my view, it clearly pointed in favor of leave to appeal being granted, close quote. Now, that worries me, that we shouldn't lose sight of the importance of this case, and maybe a higher court needs to have a look at it, maybe also tying in with Justice Malindi's proposal. What's your comment on that?
Lord, a compelling reason. My submission is that the fact that the matter is important is not enough on its own. The rest of paragraph 23 says that this is linked to the question of mootness. In that regard, there is established jurisdiction in this court that even where an appeal has become moot, the court has a discretion to hear and dispose on its merits. The usual ground for exercising that discretion in favor of dealing with it on the merits is that the case raises a discrete issue of public importance that will have effect on future matters. That jurisprudence should have been considered as a guide to whether, notwithstanding the court's view on prospects of success, leave to appeal should have been granted.
The fact that it dealt with mootness just fortifies what I'm talking about. Here we're not dealing with the matter that is moot. Okay, we've arrived at, well, when we say we arrived, some might not have arrived at the conclusion that there might not be prospects of success. But despite that, there's also another element which this court needs to look at. Now,
Yes.
at least that's there.
Yes. My submission in that regard is that the overall issue of the fate of the 178,000 permit holders is, of course, an issue of enormous public importance. But the legal issue to be decided is not. And my submission is, it's not for this court to say that because the subject matter is important, the court needs to lay down guidelines as to how the matter should be followed. There is no debate on the guideline. This is not a new issue. It's not an issue of constitutional or administrative law that a court needs to give guidance on. It's Audi. So the parallel being the Motata case, the court, and I speak merely of an analogy, the court said, we don't need to go any further than the fact that that there was no affidavit from the JSC. We will, because it's of public importance, to start to define a test that doesn't exist. So
Councillor, let me just press you on this, because I think it's important. It doesn't talk about legal importance. It says public. It's of public importance, an issue of public importance, and it's no less a court than the SCA. So that is important that we take into account.
Judge Mota, my submission is that it cannot be, however important an issue is, that when the actual issue of law is open and shut, that the SCA would want to give its time to it. That the issue must be one of public importance that requires the court's guidance. But one must be able to read, otherwise the SCA will be burdened by cases that don't require, the public doesn't require the courts to say anything about them, regardless of the subject matter, because the legal principles involved are 101. So my submission is that the proper interpretation of what the court says is, let's assume there are no prospects of success, but the court's judgment will be terribly important in future. It's moot, no prospects of success, whatever, but the court's judgment will serve the public interest in the future. Then there is indeed a compelling reason. But how can there be a compelling reason for the SCA to say, well, our law starts with audi alteram partem? My junior is pointing me to another SCA judgment. Would you give me one moment just
Yes.
to see what he's giving me? He's much cleverer than me, so I'm sure there's something. It's a judgment that Karatko, which is referred to in our heads, and it's a 2020 case, paragraph 2, and it says, in order to be granted leave to appeal in terms of section 17(1)(a)(1) and 2 of the Superior Courts Act, an applicant for leave must satisfy the court that the appeal will have a reasonable prospect of success, or that there is some other compelling reason why the appeal should be heard. If the court is unpersuaded of the prospects of success, it must still inquire into whether there is a compelling reason to entertain the appeal. A compelling reason includes an important question of law or a discrete issue of public importance that will have an effect on future disputes.
There you go. In fact, you might be hosted with your own petard, because if you look at it, it cuts nicely in the middle between matters that relate to law and matters that relate to public importance.
But with respect, my lord, the end of the sentence, it says, a discrete issue of public importance that will have an effect on future disputes. Now, and just to finish it, but here too, the merits remain vitally important and often decisive. Karatko must satisfy the court that it's met this threshold. So that is precisely my submission. Even if there are no prospects of success, the merits remain vitally important. Why? Because if the matter is going to have an effect on future disputes, then there must be merits that require the court's guidance, that require the court's decision. So properly interpreted, yes, a compelling reason can exist in a case where there are no prospects of success or where the matter's moot. But a compelling reason is not an issue of public importance per se. It's an issue of public importance where the merits of the matter are such that they require the court's judgment. Now, our submission is that this matter does not require, the subject matter is important, but the court's judgment is not required. The SCA does not have to waste its time because the court's guidance on future matters is not required. The SCA doesn't have to tell government that it must consult people before making decisions. It would be a waste of the SCA's time to do so. And the subject matter matters not. It's an ironclad principle. And the judgment would be of no value to anybody if the court just had to say that. So
Thank you. I
Yeah.
have no further questions.
Yeah.
I think we've exhausted the topic.
So just to conclude, compelling reasons is not synonymous with an important issue in the layperson sense. It's synonymous with an important issue in which parties need the court's guidance. Otherwise, why would the court, our under-resourced, overburdened courts need to worry? Those are my submissions. Thank you.
Okay, thank you, Ms. Steinberg. I think let's give an opportunity to Mr. Simmons.
Thank you, milady. Unsurprisingly, I will be echoing in part certain of the submissions and overall contentions made by HSF. I'm going to endeavor not to repeat unnecessarily, but rather to supplement those submissions. But the core of our argument before this court remains the same, which is that neither of the applications for leave to appeal should be granted. They should be dismissed with costs, both because in the case of the application of the Department of Home Affairs, because it has no prospects of success, and also because you would submit there are no compelling grounds in which to consider it. Regarding the truckers, the application of the Truckers Forum, which I will deal with at the end of my submissions, we would submit the court made the correct decision regarding delay, and there too, given the higher standard applying to the court's exercise of its discretion in that regard, there are no prospects of success. I'm alive to the debate that Justice Morcha has had about this question of compelling grounds, and I intend to get there. But first, as it were, to frame part of that debate by dealing with certain aspects of the argument on the merits. We concur wholeheartedly with Advocate Steinberg SC when she said that this is Admin Law 101. The principles at issue in this matter. And we would submit that's what this court had in mind when it started its judgment by saying that this is a matter of public interest and importance, but also of very simple, straightforward principles of law that in no way need to be developed or expanded or even disputed in any meaningful sense for us to achieve the result that this court has reached. So we concur. There is no prospect of that underlying difficulty, particularly the Audi difficulty, being overturned by any appeal court. But to move on, let us suppose that there was some merit to the submissions by the Department of Home Affairs, the applicants in this application, to the idea that ex post facto submissions or representations could be made by ZEP holders and by entities such as my client. Well, they provide no precedents or examples of how that would work, and nor do they engage in any significant sense with the reasoning provided by this court on the Motau judgment, the application of why this matter is administrative action. But we don't even need to go that far, because even on the principle of rationality, which is common cause, there needs to be a fair opportunity to affect the mind of the decision maker. And again, even if we grant the department the benefit of the doubt on those submissions, we come to the difficulty of the closed mind of the decision maker, i.e. of the Minister of Home Affairs. And there, as was raised earlier this morning, there's the difficulty that there is no affidavit of any kind from the minister. And the minister has been quoted on record as indicating that he has made up his mind on this issue. I appreciate the court dealt with this in its judgment at length, and I won't be re-arguing that case, but just to perhaps illustrate by quoting one piece of correspondence that the minister had with the Scalabrini Center. It was placed on record in this case in the affidavit of Mr. James Chapman, and I have hopefully referred the court to the correct case lines page, which is 018294.
Yes, thank you.
Yes, the Scalabrini wrote to the minister and inquired, can we ex post facto engage with you on this decision? And the court will see that the underlined section, there is no scope for reconsideration as the decision was taken after careful consideration and supported by the National Executive Cabinet. It has become practically impossible to continue with the exemption regime. So even if there was some way of granting Audi ex post facto, there cannot be in circumstances where the decision maker has indicated this kind of a perspective. And then even if the minister could have perhaps on affidavit have convinced the court that this was not in fact his overall view, we have the difficulty that there is no affidavit from the minister, nor with respect is there any convincing reason why there is not. The suggestion was made earlier this morning by counsel for the Department of Home Affairs that, you know, the minister was, sorry, the Director General was actively involved, and therefore him and the minister are, you know, more or less one and the same. But with respect, that is not our law and has never been South African law. There's no precedent for suggesting that a person who makes a decision can then allow another functionary to defend that decision. And I must add two nuances to that. First is, of course, perhaps, and I say this hypothetically for the sake of argument, the Director General did know the minister's reasoning behind the impugned decision. But this question of, does the minister have an open mind? This question of this letter that we have just quoted to the court, the DG has no particular insight into that. He had no role in that letter. So he cannot make any comment on that. And secondly, I must point out that this is not a case where, you know, in which the policy and the reasoning and the outcomes of these decision makers, the minister and the Director General, are completely one and the same. It bears mention that the minister gave a number of reasons for his decision, including the court may recall that it'll have a positive impact on unemployment and that there had been ZEP holders who were found guilty of misconduct. Those were two of the reasons given by the minister in his decision. I'm not taking the court there because I don't want to re-argue our case, and I don't want to take the court into that unnecessarily. But those were abandoned by the Director General in his affidavit. So the point is, this is not a matter in which the person who's claiming to speak on behalf of the minister does so in an obviously correct fashion. On the contrary, he has attempted on his affidavits and in giving his reasoning and his explanations to change and amend and retrofit what the minister has said. And let's also perhaps end this point by begging the question why there is no affidavit from the minister, given that there has been ample opportunity for such to be placed before this court, and little more than a confirmatory would have been required to rectify this difficulty. And yet, despite the minister's decision being challenged, despite the high profile of this matter, despite all the opportunities given to him, he has not presented evidence under oath to this court. And there are consequences to that kind of an election, including that his decision must now fall and is beyond rectification on appeal where that evidence cannot arise. So we would submit that on those grounds, on the basis that the Audi point is inarguable and inescapable, even on the evidence before this matter, there is no prospects of success. I would add that there was an attempted suggestion that this matter was policy-laden, that it was polycentric, and therefore that there should be an appropriate degree of deference by this court to the decision of the minister. But with respect, those submissions which appeared in the heads be based on inapplicable judgments do not affect the underlying nature of the Audi argument. This court was not going to the heart of polycentric disputes and all of those matters. The court was saying, follow a fair process. Do the basics required when you are potentially depriving 178,000 people of their rights, of their homes, of their jobs, of their children, of their schools. Offer them an opportunity to be heard. That injunction placed upon the minister does not change at all with regards to whether it is a case that affects one person or a case that affects 100,000 people. I must add that, to my knowledge, there's no judgment which suggests that a case where, which affects more people is inherently unlikely to be regarded as administrative action. I believe in the heads of argument of HSF, they've referred the court to judgments in which withdrawals of exemptions and decisions under the exemption provisions of the Immigration Act were regarded as administrative action. One of them was the case of Director General of the Department of Home Affairs versus De Souda attorneys. And that was a case where hundreds of matters had been, under the Immigration Act, had been unfairly delayed. But that too, unquestionably, was regarded as administrative action. And we may also have regard to other cases of, that are well known, such as the outer judgment, where the e-tolling issue was taken before the courts. In that judgment, the famous judgment is the one concerning the interim interdict, and the court in the Constitutional Court in that judgment emphasized the severe impact it would have on the fiscus and on the sort of the budgets of the state if the interim interdict was upheld. But the court stated, and there was never a dispute, that Haja applied. In fact, one would suggest that the more, the greater the number of people whose rights are affected, cannot be served as a basis to afford them the lesser protection that might arise under the principle of rationality. So, but to summarize those submissions, then, we would say, I beg your pardon if there was a question. No.
No.
I beg your pardon, there's a jump in the video feed. We would say that there's no prospects for success. That then takes us to the question of compelling grounds. And there too, Justice Mota has heard, or the court has heard from the submissions about the interrelationship of these two factors. And we concur with counsel for HSF that there must be some minimum level of prospects of success for leave to appeal to be granted. We would perhaps submit it's almost like a sliding scale. In a very important matter, it may be that you can do with less of prospects of success, because it's important that one gets it right. But if there are no prospects of success, then it goes no further than that, is the beginning of our submission. We would take it further, though, and look at the particular circumstances of this matter. This is a matter in which the practical effect, and I'm emphasizing practical effect because based on what we've said already, there are no legal precedents to be set in taking this matter on appeal. There's no new law to be made, to be developed in that sense. But perhaps the argument might be there's just a lot of people involved here and they need to have the right decision made for them. But the practical effect of this court's judgment was not to permit the ZEP to be continued indefinitely, nor even for a particularly long period, bearing in mind that it has operated in one sense or another since 2009. The court sent this decision back to the minister. Yes, it put in place an interim regime, which will protect these individuals for plus minus a year. But a year of an extension is not that big bearing in mind the 14 years this matter that these exemptions have been in place, and bearing in mind that the minister himself has repeatedly made extensions first of a year and then of 6 months onwards. So if the question is, we need to obtain the correct outcome for these people, then with respect, the path is a clear one. What the minister should do is take the opportunity afforded to him by this court to follow a lawful process and make whatever decision it is that he chooses to make, once he takes into account the just and proper submissions and representations of those affected. That is the proper way forward. In this matter, I think there have been approximately 3 extensions of the ZEP since since the termination decision.
Mm.
That illustrates how we would submit how simple and the minimal impact on the public of granting those extensions. That's different from when one ends the decision. A decision to terminate rights, to evict someone from their house, or to place someone in prison, that is the violation of rights that very often calls for full-on assessment by the appellate courts, or proper, full reasoning, because the infringement of rights there is so patently severe. But the practical import of this court's decision is not that at all. It is to allow for a short time the continuation of a system that has existed for over a decade, which the minister himself has repeatedly extended, so that a fresh decision following a lawful process can be made. With respect, that is the proper outcome for a matter such as this. So we would submit that there are no compelling grounds for this matter to be considered on appeal. There is nothing that pragmatically calls for the correct decision to be made, because this court's judgment is not the end of the road on this process, and the minister has still got his powers to consider it further. Those being my core submissions on the case of the Department of Home Affairs, I would perhaps move to make a few brief submissions concerning the Truckers Forum, subject to questions by the court. But
I think you can proceed with your argument. If there's any questions, we can ask it in the end.
Thank you, Justice Collins.
Yeah.
Briefly then, Justices, we concur. I think the point has been made that in arguing against a finding of unreasonable delay, the standard that any potential appellant would meet is a high one. And with respect, we say that the forum here does not meet that requirement. The nub of the argument appeared to be that this court failed to consider the common, that it may be an application under the principle of rationality to review the impugned decision, and that this court limited its reasoning and its conclusions to applying the Paja test. But with respect, we submit the court didn't do so. There is a slight formatting issue that may be relevant here, Justices. I'm going to refer the court to paragraph 18 of this court's judgment, which is the key paragraph concerning the delay finding. Just waiting for it to load.
Are you taking us to the Kumalo test? I think we did deal with that. We are aware of that.
Thank you, Justin. Yes, I mean, I know you were, but I just wish to point out, if I understood, and I may have missed it, but there was a repeated suggestion that this court didn't deal with unreasonable delay under the principle of rationality in its judgment. And I just wish to point out that in what appears to be the quote at this page, the quote is in fact just the first 3 lines, 3 to 4 lines. And then there is reasoning by the court itself, where the court says there is no application for this court. Accordingly, the forum has failed to comply with Paja. Critically, then, the court says, furthermore, this court is of the view that a period of over 2 years is an unreasonable delay, especially when there are no reasons justifying and explaining the delay. So I simply wish to draw that to the court's attention. The court did explicitly make this point. Then regarding the 2 more points, Justices. The first is that even if the Truckers Forum were potentially able to make submissions on this point, they would have had to have made out a case for condonation of their delay in their founding papers. And it bears mention again that nowhere in their founding papers, whether under Paja or under the principle of rationality, is there a case made out? So they too fail on rather trite principles of law. In this case, that one must make out one's case in the founding papers. And then lastly, justices, with regards to costs, again, I echo Advocate Steinberg SC when I say that the Truckers Forum have essentially brought a second case into this matter. They brought a counter application, they brought new arguments, they have necessitated the separate filing of heads of argument, this preparation of separate, arguments and legal research. They have dramatically expanded the scope of this matter, thereby inflicting costs on the applicants. And if they enter a matter as respondents and they are unsuccessful, then the ordinary order should apply. And there is nothing in Bywatch or any other judgment to which the court has been referred which suggests anything different. So we would submit that both applications fall to be dismissed with costs. Those would be my submissions, justices.
Thank you. Judge Malindi, do you have any questions?
And none at all, my sister. Thank you.
Thank you. Judge Mota?
None, my sister. Thank you.
Thank you, Mr. Simmons.
As the court pleases.
Thank you, Mr. Makari. Your reply? Mr. Makari, can you hear me? I think Mr. Makari is frozen now. The poor.
I'm glad it's not me.
I'm also glad it's not you. Let's just give him an opportunity to maybe log on once again. Shall we just take an adjournment for 5 minutes or so? I don't know. There's no response. We'll stay online. You can just take our video feed off.
I will inform the court once counsel is back on the platform, Judge.
Yeah.